Supreme Court today refused to entertain an appeal by the central government against the Karnataka High Court order, where it had ordered that central government be directed to supply a total quantity of 1,200 metric tons of oxygen to the state of Karnataka till state of Karnataka and the central government sits down together and irons out allocation related issues. Solicitor General Tushar Mehta primarily submitted that if high courts start looking into this aspect and if high courts all across the country starts giving such orders, then the system would fail. However, Justice D.Y. Chandrachud maintained that the Karnataka High Court order was an extremely thought out order and a well calibrated decision on part of the High Court, and that the state government's requirement were kept in mind before the interim direction of 1,200 metric tons of oxygen supply was made therein. This is the primary reason why the Supreme Court has refused to interfere in the appeal preferred by the central government. Senior Advocate Rahul Mehra, standing counsel for the Delhi government, today before proceedings began before a bench of Justices D.Y. Chandrachud and M.R. Shah, stated that he has sent an email to the court stating that the state of Delhi NCR has received a total oxygen supply of 86 metric tons from the central government since yesterday, and that 16 metric tons were in transit. This point was made today before the court since the Supreme Court had ordered that 700 metric tons of oxygen be supplied to Delhi on an everyday basis till the top court forms a committee to look into how a scientific audit of the oxygen requirement of each state can be calculated. Justice D.Y. Chandrachud was extremely firm when he stated that the court means business when he states that Delhi must get 700 metric tons of oxygen. He also clarified that this order of 700 metric tons of oxygen is primarily to be supplied to Delhi on an everyday basis till the scientific audit or the committee formed by the Supreme Court gives its report to the top court as to how the oxygen allocation and supply and other logistical requirements would be met. A two-judge bench of Justices Vineet Saran and Dinesh Maheshwari today heard a petition against the Delhi High Court adjournment order, wherein a petition seeking to halt the construction of the Central Vista redevelopment project was put to May 17th, since the bench of the Delhi High Court, headed by Chief Justice D.N. Patel, wanted to go through the January verdict of the Supreme Court giving a go-ahead to the Central Vista redevelopment project. Senior Advocate Siddharth Luthra submitted that the labourers who were working at the Central Vista project were residing in Sarai Kale Khan, and Shapurji Palonji group, who was in charge to develop the project, was ferrying the migrant labourers and labourers from Sarai Kale Khan to Rajpath area where the Central Vista redevelopment project is going on. He further argued that this entire project and its work was categorized as essential services and thus was exempted from the Delhi lockdown. Senior Advocate Siddharth Luthra expressed great anxiety due to the ongoing construction work of Central Vista redevelopment project, since the COVID-19 figures in the second wave were steadily increasing in the national capital of Delhi. He also mentioned that people were dying every day due to the COVID-19 pandemic, and the entire operation of the Central Vista redevelopment project as an essential service in the face of the Delhi lockdown was not permissible. However, the Supreme Court did not go into the merits of the case and has asked Siddharth Luthra to mention this particular case before the Chief Justice-led bench of the Delhi High Court on May 10th for an early hearing. The court has also mentioned that it hopes and trusts that the Delhi High Court will indeed grant an early date compared to the May 17th. Solicitor General Tushar Mehta had across the bar told Senior Advocate Siddharth Luthra that he should mention the case before the Delhi High Court and the central government would agree for a date. All India Trinamool Congress-led West Bengal government has moved the Supreme Court seeking a uniform COVID-19 vaccine pricing policy in which the central government would acquire the entire vaccine from the private manufacturers and then distribute it to the states at a uniform rate. Mamata Banerjee government has submitted that whatever orders the government had placed on April 29, that was a 1 crore dose of Covishield and 1 crore dose of Covaxin was not delivered by the private manufacturers. West Bengal government has further stated that in the face of this, the private manufacturers have told the state government that unless the full payment is made for the vaccine, there will be no delivery. However, some private hospitals in Kolkata, like Woodlands Hospitals, etc., have already got a delivery of 25,000 doses of Covishield vaccine, which was being administered by the private facility. West Bengal government has expressed concern at the asymmetry being created this way, and also says that there is a fear of inequitable distribution of vaccines if this is allowed to continue. This particular application will be taken up by a bench of Justices D.Y. Chandrachud and M.R. Shah on May 10th, when the suo motu case on the COVID-19 issue and vaccine policy will be heard. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share barandbench.com.